Compulsory and voluntary provisions. Now, we will identify separately the compulsory, obligatory or mandatory, and voluntary, discretionary or optional, provisions, features, of the 73rd Constitutional Amendment Act, 1992, or the Part 9 of the Constitution. Compulsory provisions. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of panchayats at the village, intermediate and district levels. 3. Direct elections to all seats in panchayats at the village, intermediate and district levels. 4. Indirect elections to the post of chairperson of panchayats at the intermediate and district levels. 5. Voting rights of the chairperson and other members of a panchayat elected directly or indirectly. 6. 21 years to be the minimum age for contesting elections to panchayats. 7. Reservation of seats, both members and chairpersons, for SCs and STs in panchayats at all the 3 levels. 8. Reservation of 1/3 seats, both members and chairpersons, for women in panchayats at all the 3 levels. 9. Fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any panchayat. 10. Establishment of a state election commission for conducting elections to the panchayats. 11. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. B. Voluntary provisions. 1. Endowing the Gram Sabha with powers and functions at the village level. 2. Determining the manner of election of the chairperson of the village panchayat. 3. Giving representation to the chairpersons of the village panchayats in the intermediate panchayats or in the case of a state not having intermediate panchayats, in the district panchayats. 4. Giving representation to the chairpersons of the intermediate panchayats in the district panchayats. 5. Giving representation to members of the parliament, both the houses, and the state legislature, both the houses, in the panchayats at different levels falling within their constituencies. 6. Providing reservation of seats, both members and chairpersons, for backward classes in panchayats at any level. 7. Granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. 8. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice, and to perform some or all of the 29 functions listed in the 11th schedule of the Constitution. 9. Granting financial powers to the panchayats, that is, authorizing them to levy, collect, and appropriate taxes, duties, tolls, and fees. 10. Assigning to a panchayat the taxes, duties, tolls, and fees levied and collected by the state government. 11. Making the grants in aid to the panchayats from the consolidated fund of the state. 12. Providing for constitution of funds for crediting all monies of the panchayats. PESA Act of 1996, Extension Act. The provisions of Part 9 of the Constitution relating to the panchayats are not applicable to the 5th schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, popularly known as the PESA Act or the Extension Act. At present, 2019, 10 states have 5th schedule areas. These are Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PESA Act are as follows. 6. 1. To extend the provisions of Part 9 of the Constitution relating to the panchayats to the scheduled areas with certain modifications. 2. To provide self-rule for the bulk of the tribal population. 3. To have village governance with participatory democracy and to make the Gram Sabha a nucleus of all activities. 4. To evolve a suitable administrative framework consistent with traditional practices. 5. To safeguard and to preserve the traditions and customs of tribal communities. 6. To empower panchayats at the appropriate levels with specific powers conducive to tribal requirements. 7. To prevent panchayats at the higher level from assuming the powers and authority of panchayats at the lower level of the Gram Sabha. Features of the Act. The features, or the provisions, of the PESA Act are as follows. 1. A state legislation on the panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. 2. A village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. 3. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. 4. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and the customary mode of dispute resolution. 5. Every Gram Sabha shall I. Approve of the plans, programs, and projects for social economic development before they are taken up implementation by the panchayat at the village level, and 2. Be responsible for the identification of beneficiaries under poverty alleviation and other programs. 6. Every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs, and projects. 7. The reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of panchayats at all levels shall be reserved for the scheduled tribes. 8. The state government may nominate such scheduled tribes which have no representation in the panchayat at the intermediate level or the panchayat at the district level. But such nomination shall not exceed 1/10 of the total members to be elected in that panchayat. 9. The Gram Sabha or the panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, the actual planning and implementation of the projects in the scheduled areas shall be coordinated at the state level. 10. Planning and management of minor water bodies in the scheduled areas shall be entrusted to panchayats at the appropriate level. 11. The recommendations of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining lease for minor minerals in the scheduled areas. 12. The prior recommendation of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 13. While endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the panchayats at the appropriate level in the Gram Sabha are endowed specifically with I. The power to enforce prohibition or to regulate or restrict the and consumption of any intoxicant. 2. The ownership of minor forest produce. 3. The power to prevent alienation of land in the scheduled AR. and to take appropriate action to restore any unlawfully aliena land of a scheduled tribe. 4. The power to manage village markets. V. The power to exercise control over money lending to scheduled tribes. 6. The power to exercise control over institutions and functionary all social sectors. 7. The power to control local plans and resources for such PL including tribal subplans. 14. The state legislation shall contain safeguards to ensure that panchayats at the higher level do not assume the powers and authority of any panchayat at the lower level or of the Gram Sabha. 15. The state legislature shall endeavor to follow the pattern of the 6th schedule to the Constitution while designing the administrative arrangements in the panchayats at district levels in the scheduled areas. 16. Any provision of any law relating to panchayats in the scheduled areas, which is inconsistent with the provisions of this act shall cease to be in force at the expiry of 1 year from the date on which this act receives the assent of the President. 7. However, all the panchayats existing immediately before such date shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Finances of Panchayati Raj. The Second Administrative Reforms Commission of India, 2005-2009, has summarized the sources of revenue of the Panchayati Raj institutions, PRIs, and their financial problems in the following way. 7a. 1. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRIs, but the real strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways. I. Grants from the union government based on recommendations of the Central Finance Commission as Article 280 of the Constitution. 2. Devolution from the state government based on recommendations of the State Finance Commission as per Art. 243I. 3. Loans/grants from the state government. 4. Program-specific allocation under centrally sponsored schemes and additional central assistance. V. Internal resource generation, tax and non-tax. 2. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka and Tamil Nadu are the states which are considered to be progressive in PRI's empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. I. Internal resource generation at the panchayat level is weak. T is partly due to a thin tax domain and partly due to Panchay's own reluctance in collecting revenue. 2. Panchayats are heavily dependent on grants from union state governments. 3. A major portion of the grants both from union as well as the S governments is scheme-specific. Panchayats have limited discretion and flexibility in incurring expenditure. 4. In view of their own tight fiscal position, state governments not keen to devolve funds to panchayats. V. In most of the critical 11th schedule matters like prim. Education, healthcare, water supply, sanitation, and irrigation. Even now, it is the state government which is directly responsible for implementation of these programs and expenditure. 6. Overall, a situation has been created where panchayats H responsibility but grossly inadequate resources. 3. Though, in absolute terms, the quantum of funds the union/state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources, it is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens. 4. In terms of own resource collection, the gram panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees and non-tax revenue for generating internal resources. 5. State Panchayati Raj Acts have given most of the taxation powers to village panchayats. The revenue domain of the intermediate and district panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and conservancy services, registration of vehicles, cess on stamp duty and a few others. 6. A study of various state legislations indicates that a number of taxes, duties, tolls and fees come under the jurisdiction of the village panchayats. These inter alia include octroi, property/house tax, profession tax, land tax/cess, taxes/tolls on vehicles, entertainment tax/fees, license fees, tax on non-agriculture land, fee on registration of cattle, sanitation/drainage/conservancy tax, water rate/tax, lighting rate/tax, education cess, and tax on fairs and festivals. Reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act, 1992, the performance of the Panchayati Raj institutions, PRIs, has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. 7b. 1. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3FS, i.e., functions, funds and functionaries, to the PRIs to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRIs have resources to match the responsibilities entrusted to them. While SFCs, state finance commissions, have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRIs. 2. Excessive control by bureaucracy. In some states, the gram panchayats have been placed in a position of subordination. Hence, the gram panchayat sarpanches have to spend extraordinary amount of time visiting block offices for funds and or technical approval. These interactions with the block staff office distort the role of sarpanches as elected representatives. 3. Tied nature of funds. This has two implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. 4. Overwhelming dependency on government funding. A review of money received and own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. 5. Reluctance to use fiscal powers. An important power devolved to GP, Gram Panchayat, is the right to levy tax on property, business, markets, fairs and also for services provided, like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. 6. Status of the Gram Sabha. Empowering the Gram Sabhas could have been a powerful weapon for transparency, accountability, and for involvement of the marginalized sections. However, a number of the state acts have not spelt the powers of Gram Sabhas, nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. 7. Creation of parallel bodies. Often, parallel bodies, PBs, are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBs have avoided the evils including that of partisan politics, sharing of spoils, corruption, and elite capture. Missions, in particular, often bypassing mainstream programs, create disconnect, duality, and alienation between the existing and the new structures and functions. PBs usurp the legitimate space of PRIs and demoralize the PRIs by virtue of their superior resource endowments. 8. Poor infrastructure. A large number of Gram Panchayats in the country do not have even full-time secretary. Around 25% of the Gram Panchayats do not have basic office buildings. The database for planning, monitoring, etc. are lacking in most of the cases. A large number of elected representatives of PRIs are semi-literate or literate and know little about their roles and responsibilities, programs, procedures, systems. Often for want of good, relevant, and periodic training, they are not able to perform their functions properly. Although all the district and intermediate panchayats are connected with computers, only around 20% Gram Panchayats reported to be having computing facility. In some states, village panchayats do not have any computing facility. Table 38.2 Articles related to panchayats at a glance. Article No. Subject matter. 243 Definitions. 243A Gram Sabha. 243B Constitution of Panchayats. 243C Composition of Panchayats. 243D Reservation of seats. 243E Duration of Panchayats, and so on. 243F Disqualifications for membership. 243G Powers, authority, and responsibilities of Panchayats. 243H Powers to impose taxes by, and funds of, the Panchayats. 243I Constitution of Finance Commission to review financial position. 243J Audit of accounts of Panchayats. 243K Elections to the Panchayats. 243L Application to Union Territories. 243M Part not to apply to certain areas. 243N Continuance of existing laws and Panchayats. 243O Bar to interference by courts in electoral matters. Table 38.3 Name of Panchayati Raj institutions in the states. 2019. 8. SL. No. State Panchayati Raj institutions. 1. Andhra Pradesh. 1. Gram Panchayats. 2. Mandal Parishads. 3. Zilla Parishads. 2. Arunachal Pradesh. 1. Gram Panchayats. 2. Angchal Samitis. 3. Zilla Parishads. 3. Assam. 1. Goan Panchayats. 2. Ankalik Panchayats. 3. Zilla Parishads. 4. Bihar. 1. Village Panchayats. 2. Panchayat Samitis. 3. Zilla Parishads. 5. Chhattisgarh. 1. Gram Panchayats. 2. Janpad Panchayats. 3. Zilla Panchayats. 6. Goa Panchayats. 3. District Panchayats. 25. West Bengal. 1. Gram Panchayats. 2. Panchayat Samitis. 3. Zilla Parishads. Table 38.4 Milestones in the evolution of Panchayati Raj. 9. I towards first generation Panchayats. 1948, 49 Constituent Assembly debates on the role of Panchayati Raj in Indian polity. 1950 The Constitution of India comes into force on January 26. Directive Principles of State Policy mention village panchayats as units of self-government, Art 40. 1952 Community Development Program starts on October 2. 1957 Balvantrai Meta Committee, appointed in January, submits its report on November 24. 1958 60 Several state governments enact new Panchayat Acts bringing in three-tier Panchayat system. 1959 Jawaharlal Nehru inaugurates the first generation Panchayat. At Nagaur in Rajasthan on October 2, Kerala District Council Bill is introduced in Kerala Assembly, lapses after Assembly is dissolved. 1964-77 Decline of first-generation Panchayati Raj institutions. 2. Growth and decline of second-generation Panchayats. 1978 Panchayat elections are held in West Bengal on party basis on 4th June, marking the beginning of second generation of Panchayati Raj. Ashok Mehta Committee on Working of Panchayats, appointed on December 12, 1977, submits its report on August 21. 1983 Karnataka government enacts new PR Act. 1984 Hanumantha Rao Committee on District-Level Planning, appointed by Planning Commission in September 1982, submits its report in May. 1985 Karnataka PR Act receives President's assent in July, comes into force on August 14. 1985 GDK Rao Committee on Administrative Aspects of Rural Development, appointed by Planning Commission on 25 March, submits its report in December. 1986 Andhra Pradesh follows West Bengal and Karnataka Panchayati Raj model. 1987 Karnataka holds Panchayat elections in January. 1990-92 Panchayats are dissolved and brought under administrators in Karnataka. 3. Constitutionalization of Panchayati Raj. 1986 LM Singhavi Committee submits its report on November 27, recommends constitutional status for Panchayats. 1988 Consultative Committee of Parliament appoints a subcommittee under chairpersonship of P.K. Thungan to consider constitutional amendment. 1989 64th Constitutional Amendment Bill is introduced in Parliament on May 15, is defeated in Rajya Sabha on October 15. 1990 74th Constitutional Amendment Bill is introduced in Parliament on September 7, lapses on dissolution of Lok Sabha. 1991 72nd Panchayats and 73rd Municipalities Amendment Bills are introduced in Parliament, referred to the Parliament's Joint Select Committee in September. 1992 Lok Sabha passes both the bills on December 22, Rajya Sabha passes them on December 23. 1993 73rd Amendment Act, 1992 comes into force on April 24. 74th Amendment Act, 1992 comes into force on June 1. 1993-94 All state governments pass conformity acts between May 30, 1993 and April 23, 1994. 1994 Madhya Pradesh holds Panchayat elections under the 73rd Amendment dispensation on May 30. 1996 Provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, extending 73rd Amendment Act to scheduled areas, comes into force on December 24. Kerala launches People's Plan campaign on August 16. 2001 Bihar holds Panchayat elections after 23 years, 11 to 30 April. 2001 83rd Constitutional Amendment Act, 2000 amends Art. 243M to dispense with reservations for scheduled castes in Arunachal Pradesh, paving way for Panchayat elections in the only state yet to hold them under the new dispensation. Table 38.5 Committees related to Panchayati Raj after constitutionalization. SL. No. Name of the committee chairman appointed and reported in. 1. Task Force on Devolution of Powers and Functions to Panchayati Raj Institutions. Lalit Mathur 2001-2001. 2. Expert Group on Planning at the Grassroots Level. V. Ramachandran 2005-2006. 3. Task Force for Preparation of a Manual for District Planning. SMT Rajwant Sandhu 2008-2008. 4. Committee on Restructuring of DRDA, District Rural Development Agency. V. Ramachandran 2010-2012. 5. Expert Committee on Leveraging Panchayats for Efficient Delivery of Public Goods and Services. Mani Shankar Iyer 2012-2013. Notes and references. 1. The subject of local government is mentioned in the state list under the 7th schedule of the Constitution. 2. This bill was passed by the Lok Sabha on December 22, 1992, and by the Rajya Sabha on December 23, 1992. Later, it was approved by the 17 state assemblies and received the assent of the President on April 20, 1993. 3. The Act defines all these terms in the following manner. A. Panchayat means an institution, by whatever name called, of self-government for rural areas. B. Village means a village specified by the governor by public notification to be a village for this purpose, and includes a group of villages so specified. C. Intermediate level means a level between the village and district levels specified by the governor by public notification for this purpose. D. District means a district in a state. 4. A judge of a high court can be removed from his office by the President on the recommendation of the Parliament. This means that a state election commissioner cannot be removed by the governor, though appointed by him. 5. At present, 2019, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. Presently, 2019, there are a total of 10 tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. 6. S.K. Singh, Panchayats in Scheduled Areas, Kurukshetra, May 2001, page 26. 7. This act received the assent of the President on 24 December 1996. 7a. Second Administrative Reforms Commission, Government of India, Report on Local Governance, 2007, pages 151 to 154. 7b. Ministry of Panchayati Raj, Government of India, Roadmap for the Panchayati Raj, 2011-16, pages 11 to 12, 23, and 7 to 8. 8. Report of the 13th Finance Commission, 2010 to 2015, Volume 2, December 2009, pages 424 to 426. 9. Panchayati Raj Update, October 2002, Institute of Social Sciences, New Delhi. T. 39 municipalities.